this needs to be moved, speed it up, people. So,
Right.
Right. And what I did, I think I finished the project for them too. A 2619 motion to. It was a motion to strike affirmative defenses, so I had to finish that for them.
So what did you think about this exercise that we did? Were you surprised that we
Yes.
sent that? And you probably were talking to Judge Brown. Can you believe what they have me do here? I'm spending another 5-8 hours.
Right. Well, I mean, I see your point. If you are going to hire somebody, you want somebody that's competent, willing to put in the extra work, and just try to do their best. So I totally see your point. I like challenges. It's really weird, but it's probably the first firm that I interview with that actually had an exercise. And I can say I had 2 more interviews since then, and I have another interview on Friday. So nobody came up with project for me to do. So overall, good experience. I know so much more than I knew before, for sure, especially about New York trust law.
Right. Did you listen to the Nick Wooten interview? The podcast?
No, I tried to.
And it didn't come up? Or
No.
Yeah, okay. But you read the securitization fail blog?
Yes, and I was really happy to see one of the bloggers was one of my professors for secure transactions.
Who is that?
Jason Kilborn.
Oh yeah, Gilbert.
Mm-hmm.
Okay.
He's really smart too. I like him a lot. I took him for CivPro and I took him for secure.
Was his point? Was his comment on point?
He commented on his bankruptcy expert more.
Yeah.
So yeah, I read his posting about bankruptcy. Yeah.
Well, great. And you did the very thing that I asked you to do when we first met, and that is take on a couple of other interviews. We'll talk about that in a minute. But
right.
Why don't we start? Give us the highlights and in an oral presentation. Go ahead.
Give us whatever you have decided to prepare, okay?
Okay.
Don't let us change you around.
Okay. So reading the Bestman opinion. For and foremost, it wasn't an objective reading because I knew I need to attack this. So I had to find, it was a critical thinking, what can I do to destroy this opinion? Because obviously it goes against homeowners. So thank you for all the material that you sent. It was very useful, I think. It was a good starting point. I reread the opinion, and I noticed the first time when I read it, I'm like, I remember something. I remember when a statute is in place, you need to give effect to that statute language. I remember that perfectly. I did that in several projects that I had before. So that was my starting point, and that's how I started to research this issue. So I went back and I need to find language that says that it's very important to follow the plain language of the statute. So that's how I started. So definitely I found a case law that supported my idea, saying that in interpreting any statute, we are required, first and foremost, to pay heed to the intent of the legislator as reflected by the plain language of the text. So that's the starting point, the plain language of the text. Next, I had to find legislative intent. Okay, so I went to the statute, and I tried to find various previous version of the statute, so I can go and find legislative intent. I couldn't. So I went back and I read and I researched PSA. What's PSA? Maybe I can find it out. So that's how I come up with this congressional oversight panel and what they're saying.
And that was brilliant.
Right, because it's like on point. It says what the Congress wants to say about the PSA, and you know it specifically says that any transaction by the trust that is in contravention of the trust documents, it's void. So I'm like, okay, I'm on a good track right now. Let's just go. And then I took this practice commentary argument from the blog.
My only concern on this was it came out in 2010.
Right.
Won't the plaintiff say, well, that's just 2010, we've got to rely on something that's much early? Are you relying on this as being in the congressional intent?
Well, yes, especially because there's no way to a certain congressional intent other than this. Because
Yeah.
I went back and I researched, and I went to my library at school and I asked me, how can I find out congressional intent from this statute, which is Section 105 from the older real property statutes, and they're like, you're not. So,
By the way, you were the only one to find that.
okay.
Congratulations.
Thanks. So that's, I thought, it's something. It's not the ideal legislative intent found in the statute. Okay, this is our purpose, but it never is, basically. And then just the practice commentaries, which I think they're a good argument as well. And I did find some more recent case law, as you can see, and I think,
Don't worry about the.
great,
Don't.
great. Okay, and then I tried to attack the fact that I tried to emphasize the fact that not only that there's case law favorable to the voidable part, but also there's plenty of case law and secondary sources that interpret the statute and that have applied the statute in a manner consistent with this. And there, again, I found more recent case law that support this argument. I don't think you have a version of my new project. So I found cases from 2007 holding that a trust is void under Section 7.2.4 of the New York Trust Law when the specific requirements of a trust, and in this particular case to be signed by a trustee, were missing. And there's about 5 cases that come out the same way. Basically saying that the trust instrument is to be construed as written and the settler's intention determined solely from the unambiguous language of the instrument itself. So, that's what I found. Case law favorable to and that apply the statute literally. And then I went back to the opinion and I tried to read every single case that the Bassman court relied upon in deciding that the transaction is voidable. So I took case by case and I made a note about every single case and what specific action of every single case was considered by that court void or voidable, or why. And what I found going through the cases, I think I had a little conclusion at the end saying that it seemed to me that the court struggled to find support for what they did. They just took like little sentences out of the context of those cases and tried to construe an argument. This is what I think they did. They started from here saying, okay, they started with the conclusion, the transaction is void. And I think they tried to get to their conclusion and try to find arguments, not going through a logical analysis of those cases, but they reached that conclusion and, okay, how can I find support? That was my opinion. So, I went back, and what else did I find? I made an argument, for instance, when the court cited in Red Pappy case, it was 2 paragraphs of a case. That's the entire opinion. And the court cited this case for the following idea, that if a present authority can thwart the application of Section 7.2.4, acts of a trustee without actual authority are not necessarily without legal effect, which would suggest that they are voidable rather than void. And they use the introductory signal C. Well, I went to the Blue Book and tried to find out, okay, when you use C, what kind of support do you give? So I found out that using introductory signal C means that the cited authority clearly supports the proposition. C is used when the proposition is not directly stated by the cited authority, but obviously follows from it. It was really hard for me to find how an election case regarding the State Board of Election prohibition from conducting primary elections with candidates' name on the ballot as candidate of a particular political party for the statement that the court cited this case. So I didn't find the support that they said that was, basically. So that was my short analysis of case law that the court cited. But since Saturday, I went back to every single case, and you'll see in the updated version of this memorandum, like little notes about every single case and what actions were deemed voidable.
And what did you conclude from that?
I just thought that it wasn't, like I said before, the courts just stretched their arguments in order to find for what they found. That was my overall conclusion.
So you think the court decided that it was going to rule for the bank and call this a voidable issue?
Yes.
And went back and pulled bits and pieces out?
Yes. Because they use so many words like by implication, would suggest. They're not even, I don't think they can even use affirmative words like this is the law. They're not certain. They try to stretch arguments. They say they would suggest, it's inferred, which made me conclude the way I did. Like they're stretching arguments a lot. They're stretching case law. They're trying to, to go this way for certain. I mean, they do find some support for what they're saying, but it's really hard to find in those cases which are completely different from what the court needs to decide on this point. So this is pretty much it what I did. And then Austin also mentioned that, I need to concentrate on the REMIC part of, okay, this is the REMIC trust. And what I found since Saturday is that the highly technical requirements of PSA are relevant because the trust was created for the purpose of issuing securities to be sold to investors and using the proceeds to buy mortgage notes. Since the securities were to be repaid by mortgage payments on the note, the securities became known as mortgage-backed securities. I'm sure you know this. But the PCA specifies two purposes for the trust. Number one, to establish that the transfer of the mortgages notes are true sales that become bankruptcy remote. And number two, to meet the requirements of a real estate mortgage investment conduit or REMIC pursuant to U.S. Internal Revenue Code. And the REMICs are treated as pass-through vehicles for tax purposes and enjoy tax-free exemption and bankruptcy remote protection. The first benefit of a REMIC entity serves to ensure favorable tax treatment of the bank, the securitization trust, and the investors, ideally to securitization trust having pass-through, meaning that the securitization trust is not taxed on its own income, but it is paid on receivables.
Did you find in looking in the trust whether the drafters of the trust thought it was important, whether they needed a letter of counsel if they were going to bring somebody in outside the dates, the closing dates of the trust?
Yeah, I think I saw that argument in a few cases. And I think in the brief that you attached, it was exactly the argument that you mentioned. I think that's
the Wilbur case.
Yes.
Yeah.
That's what it was. I just had a hard time finding a case that explained the REMIC part of a trust very well. I couldn't find one. I don't know if there is one or not. I looked at secondary sources as well.
That's an interesting question. I don't know whether there is one.
No, the only guy that did that is Nick Wooten, who brought in a New York trust expert from New York, and he actually prepared an affidavit, which he attached as part of that case.
Okay.
I think either for the Congress case, or I think it's for the Horace case down in Alabama. So what's going to happen, what I think is going to happen is it's going to need, to be another affidavit. And what's interesting, we called the guy in New York to say, hey, would you like to do it? And he kind of wanted to go into retirement.
Oh.
He wasn't as passionate to continue on. Otherwise, we would have had him here in Illinois. But what's going to be important for you is to see where we are in the securitization fail argument, because it started in 2010, and then to be able to pick up where the pieces dropped and say, okay, this is what we need, and where can I find that? Because it's out there.
Right.
I mean,
Right.
there really is. It's kind of like a puzzle, kind of want to
Yes.
fit the pieces together. So
Yes, for sure.
That's one of the issues that there seems to be, is there's few cases that talk about it's avoidable, but it appears that the reason why there's a paucity of law in New York is that it's black letter law, and everybody in New York understands it, and so nobody brings it up and tries to do anything with it, except for these really weird little
Right.
situations which aren't on point.
Yeah.
This is the first time I had this thought,
And
which is it might be useful to go to a New York horn book, like our Illinois Law and Practice, which we hardly anybody ever looks at, because it just lists and makes all these pithy little statements and then cites a whole bunch of cases, most of which don't say what's there, okay? But it's it's the simple black letter law that is so hard to come up many times, and hey judge, it's black letter law, show me. Well, it's hard to show them, if they're too dumb to know, then it is in fact the law. So it's a thought for us to trot over to the library and pull New York horn books down and take a look at it there, because this is very well put together, by the way. Thank you very much. This is the first time anybody's actually caused me to think this way. That hey, this really is pretty simple, and why in the world can't they get it? What's wrong? There's no law out there. Why? Because I think you touched on it a little bit, that she was angry,
yeah.
and she was whipping him.
Well, the question I
doing
have,
this, okay?
you probably touch on, but I want to go back to what you uncovered about the Board of Elections, because I thought that was one of the great flaws that you saw. Is it your opinion, Ioana, that you thought that a law clerk had pulled that case, and do you think that was basically a law clerk error that got this idea of apparent authority into the rabbit hole that we're all going down?
I think so.
So
I think so. I mentioned to that. I'm like, I think the court decided on something. I'm gonna rule this, and it's gonna be voidable. And I need you to go back and find me cases, so I can support my conclusion. So I think this is exactly what was done in this opinion. I was mentioning that every single case that the court cites, it's just so different than the facts of our case. The fact, like, there's no resemblance. You need a little bit of factual resemblance, at least for a few cases that you cite, to be on point, where there's not.
right.
And just like the way the court mentions, would suggest, by inference, by implication, I feel like even the court cannot even, affirmatively say, okay, this is the law. I'm just establishing new law right now. That's...
Well, and you spanked the appellate judge on the use of the word "see."
Yes.
So
yes,
good
I
for
went.
you.
I went back to the book. Right.
As Ted indicated, we're really needing someone who's got a good handle on New York trust law for obvious reasons. We're talking about that. But more than that, we need someone who can get their arms around what a REMIC trust is and differentiate that between a testimonial trust. And if we can get someone to really get why it's important that the letter of the law with respect to conveyance, to close the door and foreclose this idea unvoidable, then we can get the court back on track on the issue of void. What I liked about what the judge did was open the door for pointing to the New York law with
Right.
respect to how they were going to rule on the conveyance.
Right.
So that basically is a Mack truck that just got opened. We just need someone here in Illinois who has an interest in doing that and finding these cases. What's surprising to me as I sit here is we can't, because I view New York ahead of us in many ways, because a lot of their foreclosure cases, issues were brought up, Massachusetts and Florida. Why we're not hearing more out of New York? When you went and did all your due diligence search in New York and couldn't find cases that were on point, did that surprise you?
I did find the second time that I went back.
The second time?
Yes,
Okay.
when you mentioned, I think I was just focusing so much on how to destroy their opinion and like
Right.
the language of the case that,
So without getting into
Yeah.
detail, because that's not our job here today, just give me an idea how many cases you found.
a lot New York cases. I found a lot, and I think I pulled like 1, 2, 3, 4, 5 cases.
Are you surprised that the defense for Bassman didn't find those cases and
Yes.
get their ducks lined up?
Yeah, I am, for sure. Yes, there were a lot of cases, like I said.
Okay.
I was just trying to see how many and how recent they are.
All right, so let's conclude our discussion on this. Did you guys talk about your out-of-the-box idea yet?
No.
Shall we talk about that? First of all, I want you to share with us how you thought about doing this. What was the kernel, if you will, of the idea of maybe I look for this? Describe where you were in your thinking.
I think I came to this case by mistake. I don't know how you research and you go from one case from another boom, and this case pops up. And I just thought, this is, wow, there's something else but assignment, failure, of securitization failures, stuff. So that's how I decided to, bring this to your attention. And it's not in the context of mortgage foreclosure, because it's a collection case.
Right.
But I thought that, just could be useful. That was my thought process.
So given where we are in Bassman, given where we are in today's state of foreclosure, how would you use Section 8B if you were trying to think outside the box and we're trying to help for homeowners?
I would just analogize, the situation of collection that which is, which results from mortgage foreclosure or from having signed a note so that in order to acquire your property with, just credit card debts or that end up being collectible by agencies and stuff like that. So I would just probably analogize a lot and just making the argument that they're pretty much, you pretty much have money owned by a person to a bank or to, just analogizing, I think, and stretching the argument too. But I think it's something else than what was argued before. So it's a good starting point.
Ted, what questions do you have? By the way, great job on this. Let me ask you this, without going into the second round of the work that you did, the first round, how much time do you figure you spent researching, and how much time did it take you to write your first draft of the...
I think I worked on it about 2 days, let's say 6 hours, I would say, on each day, so about 12 hours for everything, for researching and writing.
And
so,
how would you research versus writing?
See, I don't know. Sometimes I have my own style. Some days they're great for research. I find so many things. But unless I write down something or I write down where to find it, that gets lost. So I usually combine everything. I find something that I really like and I want to bring that point home. I'm definitely gonna write down at least the idea and for sure the source or where do I need to go back to find that exact point. So I'm combining stuff a lot. Obviously, until it's finalized, I'm cutting a lot and adding stuff, but both.
Good.
Excuse me.
Okay. I liked your presentation, I liked it a lot. Obviously, we like you, and you wouldn't be back. Our views of what we were looking for, I don't know if they changed, but they solidified. What we're looking for really is two attorneys. One with a couple years of experience, one or two. You know, I always make the statement that I'm looking for somebody who's from an insurance defense firm who's gone and done the motion practice, the discovery practice, not necessarily taking depositions, but the written request to admit,
Right.
interrogatories, the request for document production, and all of the garbage that we lawyers throw up, either objecting